In this session, we will see about the state liability under Constitution of India. In Britain, king cannot do wrong is the rule. Nobody can find fault with his activities. Whatever he has done is right. All the courts are established by him. So courts will not conduct a trial against him. They got the right to file suit against the king in 1947, Crown Proceedings Act. But in India, the position was different. Rule of law is above all. The Hindu kings were to abide by the rule. This was the case with the Muslim kings also. But because the British people were in the court, they were deciding the cases. Their rule of king cannot do wrong has been imported to the Indian judgments. We will see how this has come. Article 300 says a government can file suit against others, others can file suit against the government. State can file suit against others and others can file suit against the state. So, center and state, we can file suit against them and they can also file suit against the third parties. There is a provision provided no legislation is passed. According to the legislation, they will have the power. The legislation can pass an act, increase the power or reduce the power. They can vary that, but no act has been passed regarding this by the parliament or the state as said by the Article 300. This Article 300 has a source from 1858. 1858 Government of India Act Section 68 has this. Subsequent to that, 1915 Government of India Act Section 32. In 1935 Government of India Act Section 176 deals with this. This has been imported to Article 300. So, now the position is government can file suit and others can file suit against the government. Now what we have to see, for which activities the state will be liable, for which activities state will not be liable. Originally since no act has been passed, only Article 300 gives the power to file suit against a third party and gives the right to file suit against the government. But which activities will be coming under this? No act has been passed. So it is only by the judicial judgments. The original first one was Peninsular and Oriental Steam Navigation versus Secretary of State. This at that time East India Company was there. The East India Company, somebody made a claim against the East India Company. It went to the court. The court decided that the East India Company had to make a payment for by way of compensation. But along with that, they made that rule. The company is doing two activities. One is commercial, one is sovereign. The East India Company was having an army. It was having a navy. So, any activities done as a sovereign work with your army or your navy, that will not come under this. You will not be liable for the act of your army or navy people. But if you will be liable for the commercial transactions which the East India Company is taking. So, since East India Company was having two activities, one is commercial, one is sovereign, the court decided you will be liable for your commercial transaction, you will not be liable for your sovereign transaction. If the army people are doing anything, army of the East India Company, then you are not liable. Many courts followed this decision. State Secretary versus Cockcroft, military area, gravels were there, somebody injured, no compensation because it's a military function. In Yeti versus Secretary of State, it was a hospital, people were negligent, hospital staff. It was held, no, it is a sovereign function. It is for the public. Government is conducting the hospital, so it is a sovereign function. In Krishnamurthy versus AP, accident with a road roller, maintenance of road is a sovereign function, so no liability. This was the question for a long time. Then Haribanchi, a case, in that case it held in the Madras High Court. The court held that you cannot treat everything as a sovereign function. You have two acts, one which comes within the municipal act, one which is not, which does not come under the municipal act. If an activity comes under civil procedure code or criminal procedure code, you will be liable. If it is beyond that, you will not be liable. For example, if the state is running a bus company, then state will be liable for its act. The decision in the Haribanchi case was, if the act comes within the municipal act, then for that negligence, state will be liable. We will not treat it as a sovereign. The state cannot claim everything as sovereign function. It made like that. But subsequent to that, constitution was there. After this, the first case, Vidyavadi, state of Rajasthan versus Vidyavadi case. It's a jeep driver, government jeep driver, accident, and one person died. The widow filed a suit. Lower court held only the driver is liable. Because of his negligence, accident happened. But subsequent to that, Supreme Court, it went to Supreme Court. Supreme Court held it is a welfare state now. You cannot claim everything as a sovereign function. You are liable for the negligence of the act of your staff also. This was the decision. You are liable for the act of the negligence of your staff. So, that vicarious liability came into existence in this case. Subsequent to that, there is another case, Kasturi Lal case. In this case, some stolen property, police seized the property, it was in the police station. One policeman took the property and left the country. The case was over, court ordered the police authorities to return the article was not there. The person filed a suit in the court against the government. But in this case, the court held seizure, arrest, all these things comes under sovereign function. So this is a sovereign function, no liability. So the Vidyavadi case, the sovereign function was relaxed, now again restricted. This is a clear case. One person took the property, he has stolen, he has left the country, but the court reasoning is it is a sovereign function, arrest and seizure is a sovereign function, so no liability. Then came the next case, Nagendra Rao versus State of AP. This is a case which dealt with all the matters, all the previous details discussed. Then it has repeated the same earlier portion. State will be liable for all the activities of the negligence of the staff. It is a welfare state. You cannot claim everything as a sovereign function. This is the latest portion. This is the case. Then in Union of India versus Savida Sharma, it is a military truck transported the army people from railway station to their camp. On the way, accident took place. Then court held the government is liable. Even though it is a military truck, what was the reasoning? The transport can be done by any other person. Why you have taken the military truck? It is not a sovereign function. It is only transporting the people from this place to other place. So the present position is the area of sovereign function has been reduced to minimum, and now the courts are held to be liable for the acts of the staff, for the negligence of the staff. The vicarious liability has come now. It is liable for the agent principal is liable for the agent. Same thing is happening now. Government is liable for the acts of their staff. Then how to claim it? Now courts are permitting writ petitions. They say it is a disturbance to the fundamental right. For example, if a case a person was arrested by mistake, then his fundamental right is affected. He is put in the prison for some time. Because his fundamental right is arrested, these writ petitions are also now permitted. If it is another civil cases, it has to go to the civil case. This is regarding state liability under Constitution of India. We will see some more chapter next time.